Good morning. Welcome to this special session of the Iowa Court of Appeals. We're so honored to be here at the Boyd Law Building today, hearing cases at the University of Iowa College of Law. We have two cases scheduled on our docket this morning, but before we introduce the advocates, I have some thank yous I want to share from our judges. I first of all want to thank Dean Pettis and the law school for the invitation to be here. Also want to thank AJ Finch, Michelle Exton, and Dean Karen Crane for their help in planning. I also want to thank the LAWR professors and the students. It's our judge's favorite part of our visit to be able to go to those classes. So thank you, Professor Kosobiak, Anderson, Gaynor, Krause, and Liebig. We really appreciate that. On the court side, I want to thank Judge Shikeli for helping organize it. Also to our staff attorney, Alex Galbraith Davis, for her work, and our administrative assistant, Christy Prescott. We really appreciate their efforts. I want to thank our bailiffs today, two of our law clerks, Nick Goodnow and Madison Rush, Iowa alums, so happy to have them help. Two of our other law clerks are here, Audrey McKinney and Justin Rempe, also Iowa grads. If you have questions for them, they'll be around, so please grab them. And we appreciate the audience being here. After our second case, we have a question and answer session. Not about our cases, but about the work of the court in general. So we're very happy to have you here. And with that, we're ready to hear the first case. The first case is State of Iowa versus James Smith. It's 24-1975. For the attorney, for the appellant, Mr. Smith, we have Webb Wassmer. And for the State of Iowa appellee, we have Zachary Miller, Attorney General. So Mr. Wassmer, whenever you're ready.
May it please the court, counsel. I'm going to start with generally the framework for analyzing a Batson challenge. First, a prima facie case must be established of purposeful racial discrimination in the exercise of a peremptory strike. Second, the state, as the party exercising the strike here, must proffer a race-neutral explanation for that strike. And third, the burden was on Mr. Smith to prove purposeful discrimination, which turns on whether or not the strike was motivated in substantial part by discriminatory intent. So in that three-part framework, this first step was really not at issue in the district court, and I don't think it's been really raised as an issue in the appeal here. The district court, though, stopped at step 2, finding basically that the reason given by the state, that counsel for the state was unable to understand VW, who was the juror at issue here, finding that that was a race-neutral reason. The district court never got to the third part of the test, which is proving.
Counsel, is that true, though? I mean, did the court actually address prong 2 at all? Or make any explicit Batson findings other than, yeah, I couldn't hear him either. Or I had problems understanding him too.
Basically, all the district court said was that the court had concerns about being unable to understand VW, and also a comment about the other juror that was at issue. And then said, I do find that those are both neutral reasons for the strikes of those two jurors. So I think that's sufficient for the second prong. But the court didn't go further. The court then just said the Batson challenge is overruled.
So with respect to the element 3, the Batson challenge, I think your allegation is the court didn't reach element 3. And because this is a de novo review, in this court, reach element 3?
Yes, I believe so, that this court can look at element 3 and decide. And I think this case hinges on element 3 because under the case law that we cited, being unable to understand a juror can be a race-neutral reason. The court, though, has to go further. We've cited a couple of federal courts, the United States versus Canaway and United States versus Chanco, to kind of talk about this particular issue when a potential juror has difficulty understanding English. And those courts say that difficulty understanding English can be a race-neutral reason. But because of the potential for a disparate impact on racial minorities or people with other national origins, they may be more likely to have been educated in a different language. English may be their second language. Therefore, the court has to carefully examine whether or not the state's reason is merely a pretext for a racial or national origin discrimination. And I think in particular, the Chango case has very important language on this. Chanco talks about English proficiency is a statutory requirement, and this is under federal law, which I don't think significantly is going to differ here from Iowa law. And states that if the prosecutor has doubts about a juror's ability to follow the events of trial, comprehend the judge's instruction, or deliberate effectively with other jurors, there can be grounds to strike them. But the prosecutor or the defendant, if the defendant's exercising the strike, has to convince the district court that the potential juror who is being struck in fact has difficulty with English.
And on this record, as short as it is, how do we know that it's more than just having difficulty speaking, but it's having difficulty understanding?
There is nothing in the record that indicates that this juror had difficulty understanding English. I agree this record is pretty sparse. It should have been developed in much more detail at the district court level. So all basically the court has before it is a very short exchange with this juror by the prosecutor. Defense attorney didn't ask any questions of this juror. We don't have the juror questionnaire. And basically then the prosecutor's statement, I had difficulty understanding this juror. The district court expressed somewhat of the same sentiment. Defense counsel did not indicate that she had any difficulty understanding. The court reporter did not indicate that the court reporter had any difficulty getting down these jurors' responses.
And the transcript kind of belies what the prosecutor said, doesn't it? I mean, we can see that there was an exchange that was understood between the juror and the prosecutor.
Yes, that is correct. Basically, the juror gave appropriate answers. There isn't anything indicating that where, like, for example, the prosecutor says, I didn't understand that, Mr. VW. I don't understand what you're saying. There's nothing like that in here.
But that's not entirely accurate. So like the state said, do you have kids to VW? VW responds, yes. The state goes back and says, do they ever tell you something you're not quite sure you believe? And the juror says, yeah, sometimes. And then the state responds, how do you determine when your kids talk to you whether or not you should believe everything they tell you? And juror VW says, I mean, I take one of them and at the end they care for each other and they say their thoughts. Now, if I'm counsel there, I don't really track. And so counsel has one of two options. They can say, I'm not tracking, sir. Like, that made no sense what you just said. Or they can bite their tongue and be like, well, I don't want to embarrass the juror for a number of different reasons, move on, but address it later. So to me, that I'm not following that. Help me follow it. Can you explain how that makes any sense?
Okay, well, it is a little difficult, I think, to follow that. But it isn't really an answer that is completely out in left field, I don't think.
And why is that?
Because he basically says that if he has a dispute between his children, he talks to them, they care for each other, they tell him what they think. And then he doesn't go further and say, then I make my decision as to which one I believe. But he's basically saying, I think that he
So what does caring for each other have to do with credibility?
Well, basically, the children who care for each other are likely to either fight a lot or not lie to each other. And certainly there's nothing that's followed up here with this answer.
And so isn't that a reason why we rely on the district court who heard that exchange?
Well, I think you also have to look a bit at what exactly the objections were and what the district court said. The state talked about also not having had to determine somebody's credibility, and then also said, I couldn't understand him. I could not hear him. The state didn't really say he gave nonsensical answers. That wasn't the reason the state gave. Now, certainly, I couldn't understand him. It's hard to say, is the state talking about, his words were such that I could not understand what those words were, or is it, I don't understand what he's saying in response to my question? Certainly, that is not very explicit by the state here. But then when the state goes on to say, I could not hear him, That would then suggest more the first type of interpretation that I couldn't really hear what he said.
And couldn't it be both though?
Potentially could, but the state's not very explicit here as to what exactly it's saying.
What's the relationship, do you think, between the juror qualifications, the requirement to be proficient in English, and the rationale for the preemptive strike here?
Sure. The juror requirements, those are the bare minimums that a juror has to meet in order to qualify as a juror. One of those is being able to understand written or spoken English. If somebody doesn't understand written or spoken English, that's a challenge for cause if they don't meet those basic qualifications. And there was not a challenge for cause made here. Certainly, there are times when a juror doesn't meet the requirement to a level that you can challenge for cause, but you then might exercise a peremptory challenge on that issue.
Counsel, in about a minute you have left, can you move away a bit from the Batson elements and talk about one of the convictions was a simple misdemeanor. And do we treat that as an application for discretionary review and grant it or deny it? It's a procedural question.
Okay, I haven't really thought about that particular question, but I think the court can treat that as an application for discretionary review. And then since it is bound up with the same issue is bound up with the other conviction, which is there is a right of appeal of, then grant that discretionary review and decide both, the issue with respect to both counts. Okay, looks like I am running out of time here, so I will be back in the rebuttal.
Thank you. Mr. Miller, whenever.
May it please the court, counsel. This court should affirm the defendant's convictions because the state did not violate Batson when it struck juror VW. This court can reach that conclusion in multiple ways. If you want to start with prong 2, I think that's all that was really raised on appeal, and it's all that the defendant raised in the district court. The state's reason for the strike was race neutral. If all you knew about a person is that they don't speak English clearly, you would have no idea of the person's race. And to violate that prong of Batson, the reason given by the state has to facially violate the Equal Protection Clause. It doesn't here. And so for that reason, the race neutral reason is valid. And you can look at cases from this court, State v. Kirk, State v. Semenko is a case the state cited out of Arizona, United States v. Chango is out of the Ninth Circuit. All of those look at a juror's ability to speak English and say that that is a non-racial, it's a race neutral reason for a strike.
Do you agree, though, that the record's kind of sparse here to determine if this juror had so great of proficiency that they wouldn't have understood it?
So I would say yes and no. I would say the transcript is not robust. Defense counsel certainly didn't develop their challenge, which was their obligation, but everybody in the district court could hear the exchange. Defense counsel, the state, the judge. If you look at the defense counsel's conduct in the challenge, just making the challenge was pretty tepid. These people are a protected class. Let's hear the state's reason. Defense counsel didn't object to the state's reasons for striking either jurors, which I would expect defense counsel to do if she could have understood the juror clearly. The district court credited the explanation and then gave defense counsel an opportunity to push back or say anything else they wanted to about the Batson claim, and defense counsel didn't come forward with, well, you know, I disagree. Here are all the reasons I actually think that this was pretextual. She accepted the state's explanation in the district court's ruling. And so the reason there's not a record, I think, is probably because it was clear to everybody the juror struggled to speak English and the state was being honest in its explanation. So, you know, in terms of what an appellate court can review in the record, maybe it's sparse, but whether or not the record actually developed in the courtroom where this happened was sparse, I doubt it. I think it was probably pretty clear to everybody the state wasn't violating Batson, and that's why we have the record we have.
Counsel, do you think the juror questionnaire that they fill out is part of the record relative to, I know this is getting more maybe epistemological, but like, is that part of the case, so to speak, like the pleadings, such that we have right to do that?
I guess I candidly haven't thought about it. I certainly don't know of a rule that would explicitly make it that way. Everybody in district court has the answers to the questionnaire, in my experience, the judge, the parties. But if you don't actually put it in the record, that happens all the time where everybody has things in the district court and you don't make it explicitly part of the record. It's not part of the record on appeal. So I think that I would be gobsmacked if someone objected to making that explicitly part of the record. But because it's not here in this case, I don't think this court can consider what the questionnaires have if they somehow had access to it. I don't on the docket have access to it, so I have no idea what they say. And so the state's reason was race neutral. I think that's pretty much where the defendant left the challenge, and so it loses. If you do go on to prong 3, you could either say it's not preserved if you think the district court didn't rule on it. I didn't argue it that way because the Iowa Supreme Court has said that district courts denying Batson claims is an implicit finding that the strike was not for a racial reason or gender, whatever the particular grounds for the challenge are. And so here, the defendant bore the burden as the proponent of the strike to show that the state's reason was race neutral. And the defendant didn't try to do it. They didn't make any argument when the district court overruled the challenge. They didn't look at the things that courts have in the past. Did this prosecutor have a history of striking jurors of a particular race in the past? Did the county attorney's office have that practice or any evidence of that? We don't know how many jurors who were minorities were on this panel or on the pool. We don't know. Certainly, there's no argument that defense counsel pointed to saying these jurors were questioned in an unfair manner. You've read transcripts where, look at Flowers, where the prosecutor goes on and on and on asking, a bajillion questions to try to trip up a juror that they want to strike. That didn't happen here. We don't have a white juror or a juror who wasn't Black who had trouble speaking English that was left on the jury. So we don't have any of the things that courts look at.
Counsel, do you think there's a difference between trouble speaking English and trouble understanding communicative information in English?
Yes. Yes, I do.
And does that distinction matter in this case?
No. The reason it doesn't matter is because the state didn't try to strike the juror for cause. The Iowa Code requires being able to understand written, spoken, or signed English to be a juror. That does not say anything about being able to speak English clearly. So the state had to use a peremptory challenge, and the state can use a peremptory challenge for any reason at all, as long as that reason doesn't violate the Constitution. So
And is that kind of a sliding scale then, what would justify a strike for cause, the level of proficiency versus it's just hard to understand the person? And where does that come to? Well, they had a strong accent, and then it becomes sort of pretextual for the strike.
So I think that to show pretext, the defendant has to bring forward some evidence, an argument to show that it was pretext once that reason's credited. Here, there was none of that. So I don't think that the reason in that sense matters. Now, maybe what I think your question is getting at is if the state gives a bad reason, like for example, it's been approved like saying someone has an unkept greasy beard is a reason for striking them. Well, that's race neutral, but maybe it's not the best reason to strike someone logically. So we're going to look at that a little more questionably. If you have a thing that's like going to have a huge disparate impact, that could be evidence of pretext, but absent anything else, you need more because then you'd just be losing the claim on prong 2, especially with the district court finding.
And you point out what the defense counsel should have done, but here shouldn't we have some kind of record, because you rely on Kirk, and Kirk was a case where the prosecutor gave a fairly lengthy exchange with the juror about understanding and the language barrier. And on this record, we just have, I couldn't understand him when he spoke. I could not hear him.
Your Honor, I think that first of all, the district court credited that and the district court was there. And I think that there's multiple reasons that that could happen. As Judge Sandy suggested, the prosecutor didn't want to alienate the juror, make them look like the state didn't like them. Maybe the other jurors are like, ooh, this exchange, this is getting weird. I'm not into it. And so the state, I think, is entitled to say, I don't want to alienate this jury panel. I don't want to make this person look bad and stop, because they have peremptories and they can strike people using their peremptories. And I've been in a trial courtroom where co-counsel is going on and on back and forth with a juror. And it's just like, stop it. We can just strike them. You're making people not like us. And so, I think that
I've been in a courtroom. You can do it in a way that does not offend the other jurors, but
Sure.
develop your record.
Sure. And I can understand that, but not everybody is able to do that, every single time, and they shouldn't have to do it either. And you can also, I would say, if you stand there and question someone for a really long time, you can end up looking like you're singling them out because you want to strike them. And it doesn't ever rise to the level of for cause. And then that turns around and gets used against trying to show that the state's reasoning was for an improper purpose. And so I think that trial attorneys need to have a lot of latitude to conduct voir dire how they see fit. And that's why we have district courts to police this. This judge was in the room with both parties and all the jurors. And again, so was defense counsel. And defense counsel didn't ever object to anything that the state did beyond making the challenge. They didn't hear that explanation and go, Your Honor, no. He spoke very clearly. So I think that's why we have considerable deference for the fact findings of district courts in these matters. And
That's if we had that. And it just doesn't seem like we have that.
Your Honor, the Iowa Supreme Court's directed courts to treat Batson denials as implicit findings that there was no pretext, that there wasn't a racially discriminatory reason. And here the court credited the explanation and then said it doesn't violate Batson, which is saying either that the defendant failed to prove their claim that they needed to, or the state did not exercise its strike based on race. And so that's
You
sufficient.
said that also have concern being able to understand.
Right.
And we've already kind of talked about that distinction between understanding and speaking, and to me, this relates to speaking,
Right.
not the understanding.
And that's why it's a for cause challenge and not, or excuse me, a peremptory challenge and not a for cause challenge. And that's a proper basis to exercise a peremptory strike.
Why?
Why?
So bear with me.
Sure.
Trial starts,
Sure.
right? Opening statements. You as prosecutor aren't going to look to that juror if they're impaneled and sit in the box and going, what'd you think of what I just said? And be like, oh, I didn't understand what they said very well. So, I mean, really what you're talking about is you have concerns, I presume, that if they can understand English well, but just can't speak it the best, would the concern be that during deliberations, other jurors might not be able to collaborate with them as well? Is that the concern there?
I think that's definitely a possible concern. It's also possible that you question the ability to understand, but you don't think it rises to the level of a for cause challenge. And so you say, I don't want to take my chances. I have to prove this case. And if I don't think a juror can deliberate effectively, that could prohibit me from, I could lose the case just because I can't carry the burden with this juror based on a language barrier. And so I think either of those are perfectly valid reasons a prosecutor would.
But again, language
Sure.
barrier is different than he has an accent.
I completely agree, Your Honor, but I think that sometimes you maybe don't have the standard for a for cause challenge, but you still have your doubts about, people lose for cause challenges and still are like, well, I don't really want that juror and I get my peremptories and that's why we have them. And so I think that the state doesn't have to just accept a juror that it's not sure can do the job of deliberating based on the facts that were brought forward in district court. And so because the state didn't strike VW for an improper basis, this court should affirm the defendant's convictions. Thank you.
Thank you. Mr. Wassmer.
Thank you, Your Honor.
Can you start with why the defense counsel did not push back?
I have no idea. I was not there. So I can't speak to that. Probably should have.
That it was the defense counsel burden to show that.
It's clear that under the Batson test, under the third prong, the burden is on in this case, it would be on the defendant, Mr. Smith. I wanted to mention a bit the issue about jury deliberations. The attorney for the state never proffered that as a reason as to why they were striking this juror, that they thought that this juror would be unable to effectively deliberate. Generally, you have to think about what does a juror do during a trial. They only speak twice. They speak during jury selection and they speak during deliberations. During the presentation of the evidence, there is where the ability to understand English is the important factor because they are listening to the witnesses, they are looking at exhibits. They also have to be able to understand the judge's instructions, which are in English. They have to be able to understand the closing arguments and the opening statements that the attorneys make. But here we have no evidence at all that this juror was unable to understand English. All we have is the state saying, I couldn't understand him when I spoke. And is that because he doesn't understand English, or is that because he just has an accent because English is not his first language? I think the line here in these kind of cases between pretextual and a race neutral reason is a very difficult one for a court to decide. And the court basically just has to look at what evidence do you have before you, which we've all agreed, I think, that it's pretty sparse here. And decide, does this cross the line between a race neutral reason into a pretextual reason?
But it's difficult for us, isn't it, if there's not that argument, the defendant's behalf at trial, to kind of fill in the blanks.
I agree with that. It's difficult when there's nothing that's stated by defense counsel as to why they want to push back at this. And like I said, I don't know the reason for that, but it is a de novo review. So this court has to look at that issue based on what evidence you have in front of you. And certainly a court can decide that you don't have enough evidence to make a call, that it's a pretextual reason. But I think there is enough evidence here of that, basically on the lack of evidence that this juror couldn't understand English, or that there was some other reason to believe that this juror could not be an effective juror in the case. I did want to quickly answer my thoughts on your question, Judge Sandy, on whether or not the juror questionnaire is part of the record. I do not think it is. In cases that I've had before with juror issues like this, one party or the other has marked that juror questionnaire that's an issue as an exhibit, and it's been put into the record as a court exhibit. It doesn't go back to the jury, of course, but it's so that it becomes part of the record. Because at this point, I don't know how this court would track down that questionnaire if it hadn't been marked as an exhibit and put into the record.
I guess my question is, it's not part of the pleadings, though. It's not filed with the clerk.
Nowhere that I
retained with
saw,
the clerk.
nowhere that I saw. Basically, the juror questionnaires, you get them from the clerk of court in advance of trial. You look through them. You have them in front of you. The parties have them. I'm not sure that the judge looks at them. The judge probably could, but I don't know if the judge does.
I always.
Yeah, some judges may, some judges may not. It's hard to say. But certainly the parties would have them and look at them. And I don't know for one way or the other if there's anything in this juror's questionnaire that would have been relevant to this issue or not. But overall, the state really did not give a very effective reason for striking this juror. Basically just that the counsel for the state could not understand that this juror said. That appears to be a pretextual reason, and that therefore this court should reverse Mr. Smith's conviction and sentence and remand for further proceedings. Thank you.
Thank you. Thank you to both advocates for your very responsive arguments today. We appreciate it. And we appreciate you being argue at this venue. We will consider State versus Smith submitted, and we will have a written decision for quickly.